to the federal court. Oh, hang on, sorry, have I missed some of that?
Sorry, did I? No, yep. So go on.
So am I now starting at the top of this page?
Yep, the top of the page. So there are two parts to this question. It's quite a long question, or long problem.
Okay. Did I finish the first page?
Yes, you did. You already finished the first page.
Okay. A report of the ASS agent states that at the last meeting of Makepieces in a collective, there was much discussion about the book. The consensus was that the Caledonian government could not tolerate a decision by the Australian government to allow its importation. It would be likely that Caledonia would reduce the level of its diplomatic representation of Australia and would call off the proposed visit of the Prime Minister. After waiting a considerable time for a reply, a representative of Makepeace phones the Attorney General and is told that the matter is being considered by an unauthorised person. The authorised person is out at lunch, but an assistant says, "We're still considering your request, although we've made some progress. The good news is that we've decided that you have a good reputation and that you conduct educational activities to which the book relates. The bad news is that we suspect that you have ulterior motives for wanting to import the book. If this turns out to be potentially fatal to your application, we'll get back to you so you can give your side of the story, but that may not be necessary. Makepeace wants to know whether it can apply to the federal court or the federal circuit court for review of the decision that Makepeace may have ulterior motives for seeking to import the book."
Thank you. Yeah, I just noticed that I think 45 minutes of the session had not been recorded. I failed to turn it on. Anyway, I'm gonna provide the answers to the questions, but I forgot to turn the recording on. Okay, would somebody care to answer this particular question? So Makepeace wants to know whether it can apply to the federal court or the federal circuit court for review of the decision. Did somebody volunteer there? Yes, Vivian.
I would just like to add that I want to bring up the conception of matter. That's so at the heart of the constitutional conception of matter is a controversy about rights, duties, or liabilities which will, by the application of judicial power, be quelled. The controversy must be real and immediate. So I think any hypothetical questions give rise to no matter. So I don't think Makepeace sorry, let me see the question. So I don't think Makepeace can apply.
Why is that? Because there is no actual controversy.
Yes, it's just, it's not real. It's imagined, I think.
Makepeace is saying that there is an actual controversy because it should have the right to import a book. Everybody else is able to import a book. And so therefore, it would appear that the minister's deputy has, or the Attorney General's deputy or authorized person has refused to allow the importation of the book. So in that case, there is an actual controversy because the rights and interests of Makepeace have been impaired by the failure of the Attorney General to issue a license to import. What do you think? So there is standing. There seems to be an actual controversy because it would appear that the Attorney General has not issued a license to import, which is important for the importation to go through. So what do you think? Do you think that an application to the federal court or the federal circuit court for review would prosper? Okay, the basis for making the decision seems to be improper. Okay. So in that case, there would be a ground for judicial review. Is that the assertion there? So there is a legal basis. Okay. So if there is an improper decision, would it mean, therefore, that recourse to judicial review is then available? What do you think?
Yes.
What do others think? Would anyone wish to say something?
So they haven't actually made the decision yet. So
Good. Yeah, go on.
So would this be like the failure to make a decision, which would be challenged, but it seems they're still in the process of making it. But I know the question seems to be limited to the decision that Makepeace may have ulterior motives. And I'm not, like, to me, the wording of that is strange because it doesn't seem to be a decision that they have ulterior motives. That was just a comment made by someone.
Very good.
So so are they trying to challenge the fact that they believe that they have ulterior motives, or the fact that they have delayed in making the decision?
That's right. So the point there, as pointed out correctly by Edward, is that it could be argued that there has been a reasonable delay in making the decision, and in that case, potentially, had this decision be based on an enactment, which potentially could be maybe on the Customs Act, then an argument could be made that the judicial review under the ADJR Act is available if it were based on an enactment, such as the Customs Act. But that's difficult to argue that there has been unreasonable delay, because there's no showing that the Attorney General has refused to issue a decision for the past 3, 4, 5, 6 months. So it's difficult to argue unreasonable delay.
You could argue that by failing to make a decision and deliberately delaying, they're in effect making a decision. Well, they're not making a decision, but they're taking an act which is final, operative, or determinative. By not making a decision, they have nowhere to go. They've effectively made a decision by not making one.
That's right. It could have been argued that way. However, as we said, there seems to be there hasn't been a sufficient lapse of time for a conclusion to be made that the Attorney General or his designate are refusing to make a decision, or have actually issued a decision denying the request. It can't be said. So the status actually is that there is no decision. There is, in fact, no final or operative or determinative decision, as it is. If you look at the facts, there is no showing there that a decision has been made by the Attorney General. So in the absence of a final or operative or determinative decision in relation to the request of Makepeace for an importation license, then judicial review is not yet available. And this is according to the case of Australian Broadcasting Tribunal versus Bond, that only when there has been a final or operative and determinative and substantive decision can judicial review be available. The point there is, the reasoning behind this is that if you were to apply to an administrative agency, for example, it is likely that an administrative decision will have to make multiple decisions in the process. It could be like, should you be allowed to submit documents? Should you be given more time to submit certain documents? And what if certain documents are refused? Should you be permitted to argue why those documents should be submitted? There could be questions about asking to actually talk to an officer of a designate of the minister in order to plead your case. So in all of these instances, the ultimate decision you wish is for a license to be given. But prior to the issuance of the license, there are actually multiple decisions in the process that a minister is likely to make. But the only time when a judicial review is actually available is when there is a final or operative decision that is made by the executive, because only then is it likely that there has been a substantive decision on the request. Because if it were possible to litigate every single micro decision made by the executive, then recourse to the judicial review will just be oppressive and uncontrollable. The courts will be required, to examine the legality of every single decision made by an administrative agency. And this is the reason why the High Court has been clear in the case of Australian Broadcasting Tribunal versus Bond that it is not every administrative decision that can be subject to judicial review. Only those administrative decisions which are final or operative and determinative, as well as being substantive, that can be the subject of judicial review. Okay, so in other words, if it seems to be a premature decision which hasn't really decided on the actual, substantive request, then there is no final decision that can then be the basis of judicial review. Okay, so it's 8:14. I think it's about time to wrap up. There's a question on the Australian Broadcasting Tribunal versus Bond. I will respond to that in a model answer, which I will open in Moodle by tomorrow. In the meantime, any other questions before we end tonight's session? And I thank Edward, Vivian, Millie, and Martin for joining tonight's session. And I apologize to those who will be listening to this video recording for failing to turn on the recording early on in the session. But the answers would have been in the suggested answers to the Moodle discussion questions, which I will make visible in Moodle by tomorrow morning. Any questions before we end tonight's session? None? Okay. So thank you everyone for joining tonight's session, and I hope to see you again on Thursday next week. Good night. Bye.